Thanks everyone for joining this training. So I'm going to be looking at inherent jurisdiction today, but also in the context of, but also assessing capacity in the context of undue influence as well. So I'm hoping you'll find this useful. So in terms of our objectives, we want to hopefully develop an understanding of overarching responsibilities under the European Convention on Human Rights, develop a broad awareness of the legal frameworks that we use in healthcare, and our focus is going to be on the Mental Capacity Act. We're going to look at how we assess capacity where we think there might be undue influence, and a case all the way from Singapore in terms of that. And then also looking at when we might be looking at inherent jurisdiction of the High Court, with the emphasis that this would be when you'd be getting your legal advice, if you think that might be required. Just a little health warning, I'm not a lawyer, so this training is not legal advice, and what I'm going to hopefully be achieving is making you aware of the inherent jurisdiction if you're not already aware of it, and some guidance around when you might need to think about it and getting advice about making taking steps towards making an application. But obviously, please do get advice from your legal teams or professional leads within your organisation if you think that might be needed. Helpful to keep an eye out on resources that might be available, and a lot of law firms and barristers' chambers do webinars that will keep you up to speed on the latest developments. And just highlighting, medical law is an ever-evolving topic, law and ethics. From a slightly nerdy point of view, this is the first edition of Mason McCall Smith Medical Law and Ethics from 1983, and as you can see, the 2023 version is far larger and it also has a lot smaller print. So you know, the law's constantly developing in this area, and it's really important we do keep ourselves up to date on the any developments that are relevant to our practice. Another useful resource to be aware of is the National Mental Capacity Forum, and the link to their archive or catalogue of webinars is available via that link, and that will provide you with lots of webinars and CPD, which is really valuable on a number of topics, including executive functioning and DNA CPR for discussions. So a really useful resource just to be aware of, separate to the topic that I'm touching on today. Also, just to make you aware that some of the topics I'm going to be talking about today, some people might find challenging. So do obviously, please do drop off the training if you do finding the topics difficult, and also just some of the numbers that you can call if you do need support, and obviously within your own organisations there should be access to support services as well that you can find. So Lynn is going to pop some initial questions up for you. This is just to help us gain an understanding of what the level of understanding, confidence is within the room, and then we'll do the same questions afterwards. It's really just some quality assurance for us to measure how helpful this training is. Your names aren't recorded, so it's anonymous in terms of what you vote, and just go with your sort of initial thoughts. So don't dwell on the question and the answer too deeply. Just go with your sort of initial thoughts, and they'll pop up. There's 5 of them, so you know, in fairly quick succession. If you do want to re-look at the polls, I think they'll appear in the chat, so you can always go into the chat to scroll through and vote if you don't get the opportunity to do so when it's on your screen. Once you've voted and you've got to your final one, question 5, you can close the poll via the cross at the top right hand corner of the box as well. So that's how you remove it from your screen.
And this is the last one, everybody. You'll be pleased to know. Question 5.
Okay. So I'm going to give it a few more seconds because I can see the majority have voted on that last one, give or take. And like I say, you can access it in the chat if you do want to. Okay. So I'm going to start just by touching on the European Convention on Human Rights. So looking at the overarching convention rights that we need to be mindful of, I suppose, in our day-to-day practice. And they are incorporated into our domestic law via the Human Rights Act. So it's a requirement of Section 6 of the Human Rights Act for public authorities, it states in Section 6 of the Human Rights Act that it's unlawful for public authorities to act in a way incompatible with a convention right, so in a way that's incompatible with the European Convention on Human Rights. So we need to make sure that we're cognizant of these rights in our day-to-day practice, and that we don't act unlawfully, and that would be either breaching or not acting in a way that's consistent with an absolute right. And where it's a qualified right, and we'll come on to this in a minute, it's how we've balanced those two competing rights in our practice. So we've got the right to life, the prohibition of torture or inhuman or degrading treatment, right to liberty and security of the person, the right to a fair trial, the right to respect for private and family life, and prohibition of discrimination. So these are probably the key convention rights that we'll be thinking about in our day-to-day clinical practice. And we may well, as I say, find ourselves in a position where there's a bit of a tension between different convention rights. So we might be having to think about how we balance those in our practice. As I say, some are absolute rights, we can't interfere with them at all. Others are qualified rights, so we can interfere with them as long as we are doing so in a way that's proportionate and it achieves a legitimate aim. An example of that, as it says on the slide, is the right to private and family life. The other might be, for example, the right to liberty and security of the person. If we're depriving someone of their liberty, that would be an interference with their Article 5 right. Article 8, the right to private and family life. If we're restricting contact, for example, with someone and their relatives, that would be an interference with that Article 8 right. So we've got to be mindful of these rights in our day-to-day practice. And if we're ever doing something that might interfere with a qualified right, we need to make sure we're clear about why that interference is legitimate and proportionate. And there's two main pieces of legislation that help us in our day-to-day practice in terms of thinking about how we can protect the people's human rights in our day-to-day practice. We've got the Mental Capacity Act, and that's considered to be a supportive piece of legislation. And then we've got the Mental Health Act, which is sometimes considered to be a more coercive piece of legislation. So this will help us protect the right to life, which is an absolute right. So if someone's life is in danger and there's a real immediate risk of harm to the person, we might find ourselves using the Mental Health Act if they meet the criteria for detention under the Mental Health Act, for example, to prevent them from causing harm to themselves. We might be using the Mental Capacity Act in the example of someone who's acutely unwell, needs emergency admission to hospital in their best interest, and that'd be again potentially protecting that Article 2 right to life for someone who is acutely unwell, for example. We can also use these two pieces of legislation, for example, to deprive people of their liberty. So again, Mental Health Act, deprivation of liberty can be authorised under Mental Health Act, and the statutory Dole's process provided within the Mental Capacity Act provides us with a legal framework for depriving people of their liberty. So it's just a high-level summary of human rights legislation, European Convention on Human Rights, the Human Rights Act that pulls that into our domestic law, and then legislation that supports us in upholding those rights in our day-to-day practice. So turning to the Mental Capacity Act, and being mindful that we are thinking in particular about situations when there's coercion and undue influence. So that's going to be the main focus of the examples in terms of the Mental Capacity Act for today. But before we go on to that, I do just want to flag that sometimes we actually have to be a little bit careful about the use of the word capacity, because it can mean different things depending on the circumstances you're in and the context of the decision that's being made or the legal framework that's being applied. So capacity won't always mean capacity in the context of Mental Capacity Act, and it won't always be the same test that you're expected to apply. So I don't want to sort of overcomplicate this, because for the vast majority of you in your day-to-day practice, you'll be assessing people's capacity within the meaning of the Mental Capacity Act for care and treatment decisions. But you might read things, particularly if it is in relation to the inherent jurisdiction, where commentary or the case law itself refers to capacity, and it's not necessarily going to be referring to capacity in the sense of the Mental Capacity Act. It will be referring to capacity in a more broad sense in terms of the person's capacity to make decisions potentially. So as an example, we've got Sexual Offences Act 2003, which has capacity defined in a specific way for offences relating to I can't remember what it is now. I thought it was on the slide, but it's something along the lines of sexual interference with someone with a mental disorder or a disability impeding choice, something on those lines. So it's got its own test within those sections of Sexual Offences Act. You might sometimes have the police referring to capacity, and they might mean that in terms of mens rea, so the guilty mind in terms of a criminal offence. And as I say, in the inherent jurisdiction, you might have someone in the case law being referred to who has capacity within the meaning of the Mental Capacity Act, but is considered not to have the capacity to make decisions in the broad sense of the word, because of undue influence, for example, coercion, or for some other reason. So just being mindful of that. And the Mental Capacity Act does make that clear, because when it talks about people who lack capacity, it is very clear that this is only for the purposes of this Act. So when we're looking at coercion or undue influence, one of the leading cases that comments on this topic, Munby J gave what he considered to be an example of what this might look like. So it's where a vulnerable adult's capacity or will to decide has been sapped and overborne by the improper influence of another, where the influence is that of a parent or other close and dominating relative, and where the arguments and persuasion are based upon personal affection or duty, religious beliefs, powerful social cultural conventions, or asserted social, familial, or domestic obligations. The influence may be subtle, insidious, pervasive, and powerful. In such cases, moreover, very little pressure may suffice to bring about the desired result. So quite a long definition there. And I suppose what we just need to be mindful of is there's likely to be a spectrum of coercion and undue influence, from the very obvious coercive controlling behaviour that might be fairly obvious to us, to that more subtle intervention or coercion that we just need to be more mindful of, and have that professional curiosity in terms of thinking about what might be influencing our patients' decision making. So when we are looking at decisions being made under the Mental Capacity Act, we've got the principles that we need to apply when we're applying the Mental Capacity Act in our day-to-day practice. I'm hoping that all of you are broadly familiar with these principles. So we've got the assumption of capacity until we form a reasonable belief the person lacks capacity. That we're not to treat people as unable to make a decision until we've taken all practicable steps that we can to support them to do so, and those have been unsuccessful. That we're not to treat them as unable to make a decision merely because the decision that they're making is unwise, or we perceive it to be unwise. And then if we assess them to lack capacity, we're then going to be acting in their best interest, following that statutory framework set out in Section 4 of the Mental Capacity Act. And before we do that, we need to be thinking about whether we are using the least restrictive way of achieving that goal that we want to achieve in their best interests. So we're doing it in the least restrictive way. So we've identified what's going to be in their best interests. We're then looking at what is the least restrictive way of achieving that. So when we're thinking about coercion and undue influence and the Mental Capacity Act, we are going to be thinking about practicable steps. So have we taken the practicable steps to remove that undue influence if we think it might be affecting the person's ability to make the decision? So that might be seeing the patient on their own, for example, for all, if not some of our assessment. And that's likely to be important from the point of view of that. We also need to be mindful of some cautions around the application of these principles. So in relation to the presumption of capacity, what we don't want to be doing is relying on this when there's reason to question the presumption of capacity. So if we do have concerns about coercive controlling behaviour, that might be enough in some circumstances to question the presumption of capacity and do an assessment and not rely on that presumption. And particularly, if the person is making an unwise decision that puts them at risk of serious harm, we might want to do a formal assessment of their capacity to make sure they are making a truly autonomous decision. And then also making unwise decisions, just being mindful that this is not a universal right. So sometimes we hear people say, there's a right to make an unwise decision. The principles in the Mental Capacity Act are for the purposes of the Mental Capacity Act. So they're only in the context of this legislation. So there are other situations where someone might be making an unwise decision and we might intervene. An obvious example would be someone who has capacity but is mentally unwell and needs to be treated for their mental illness. We've got the Mental Health Act. That's a legal framework that can be used to treat someone who's mentally unwell for symptom or manifestation of their mental disorder. And you can treat someone under Mental Health Act irrespective of whether or not they've got capacity. So it's not just a general right to make unwise decisions. And this is also where if you've got someone who is exceptionally vulnerable and they've been assessed to have capacity, but they're subject to, for example, coercion, controlling behaviour, undue influence, we might still want to explore alternative legal frameworks. And if we've exhausted those, we might be thinking about, is there a gap in the law? Do we need to consider an application to the High Court to exercise its inherent jurisdiction to protect this person? And we'll come on to that because some of that might not entirely make sense now, but hopefully as we go through the training, it will make some more sense in terms of what I mean by that, and applications to the High Court. Also, for the sake of completeness, the use of the word merely here is quite important, because what it's effectively saying is the assessment of capacity isn't an outcome-based assessment. We're not looking at the outcome of what the outcome of the decision would be and using that to form the view that the person lacks capacity. It is a functional assessment, so can the person make the decision? That's what we're testing when we're assessing capacity. But an unwise decision might be a reason to question the presumption of capacity and do an assessment. And it also can contribute to a conclusion that the person lacks capacity. So making an unwise decision, that can be part of your rationale for forming the view they lack capacity, but it will have to be supplemented with additional evidence. It can't be the only, still have to be applying that functional test, understand, retain, use, weigh, communicate, in terms of forming that reasonable belief that the person can't make the decision for themselves. And the assessment itself, so the assessment of capacity, it's helpful to do a recap of this. And if anyone's not aware, the approach to assessing capacity has changed in recent years. So we had the case of JB in 2021. And in that case, the Supreme Court said that the approach to assessing capacity that's set out in the Code of Practice is wrong. So in the Code of Practice, we've got stage 1 diagnostic test. Is there an impairment or disturbance of the functioning of the mind or brain? If there is, you then move on to stage 2. Can the person make the decision? Can they understand, retain, use, weigh, communicate their information, use, weigh that information, and then communicate their decision? And what the Supreme Court said in JB was actually, you want to be doing that functional test first, and then it's only if they can't do one or more of those things that we need to move on to that diagnostic test. Is there an impairment or disturbance? And then there's been another very recent case where there's been a comment that actually it's probably not helpful to refer to it as the diagnostic test. And as you'll see in the next slide, we probably want to start calling it the mental impairment test because it doesn't require a formal diagnosis, but we'll come on to that in a moment. So when we're assessing capacity, our first question is going to be, what is the decision we're asking the person to make? And we don't want to frame this too narrowly. I'm a healthcare professional by background. So the easiest example for me would be if you have someone, for example, with a chest infection and you're worried about them and you want them to go to hospital for further investigation, tests, etc. You might be tempted to say that the decision you're assessing capacity for is admission to hospital. Do they have capacity to make a decision about being admitted to hospital? But that's actually only one aspect of the relevant information to that decision. So what you're actually asking them in all likelihood is to make a decision about care and treatment for this chest infection, of which one of the options is admission to hospital. The other options might be, well, it might be doing nothing. It might also be having oral antibiotics at home. It might also be having support from any hospital avoidance support that might be available. So if you do have kind of a hospital at home service available, it might be intravenous antibiotics in the home environment, for example. So it's going to depend on the options available, but the decision you're going to be assessing their capacity for is care and treatment for that chest infection and going through all the options available to them, risks and benefits of those, and then how they're weighing up those options, those risks and benefits in terms of then forming the view that in this case, they don't want to go to hospital, for example. So what's the decision we're asking? the person to make, and trying to be quite clear about that, because that's then going to help you. I've already touched on this in the example I just gave. That's going to help you identify the relevant information. So what are the things you want this person to understand, retain, use, weigh in order to make the decision, and then communicate that decision to you. In the Mental Capacity Act, it does say that this must include the reasonably foreseeable consequences of making the decision one way or the other, or failing to make the decision. And reasonably foreseeable is what would a reasonable person in that patient's position foresee as a consequence of that decision. So we don't want to be, going into the realms of excessive speculation that no reasonable person would foresee as a consequence. Is what would you expect a reasonable patient to foresee as a consequence of that decision, one way or the other, or failing to make the decision. I don't have it here on the slide, but the case of JB also said that it can include risk of harm to others or risk to others in some circumstances where that might apply. One example of that would be capacity to engage in sexual relations. If you're assessing someone's capacity to engage in sexual relations, one piece of relevant information that they need to understand, retain, use, weigh in order to make their decision is that the other person can withdraw their consent at any time. So while that would be ultimately a consequence for the other person in terms of the effect it would have on them if the person whose capacity has been assessed didn't understand that if they then withdraw their consent, they need to stop. The adverse effect is most likely going to be on that other person. It's importantly that for the purposes of assessing capacity, the person does understand that as part of the relevant information. So if there is a risk to others that's considered to be part of that relevant information, it's important that the person is made aware of that and can understand, retain, use, weigh that as well. So once we've identified the specific decision and the relevant information, that's when we're then going on to our first stage of our assessment, our functional test. Can the person make the decision? Can they understand that information, retain it, use and weigh that information, and then communicate their decision to us by any means? And then if they can't do one or more of those things, that's when we then move on to stage 2. And as you can see, I've referred to it here as mental impairment test. Is there an impairment of or disturbance in the functioning of the mind or brain? And this recent case of Stadishka that went to the Court of Appeal this year, there were some submissions on behalf of the charity Mind that diagnostic test is misleading, and we should be thinking about mental impairment test, and that was adopted by the judge in that case. So there's no need for a formal diagnosis. For the purposes of the Mental Capacity Act, we need to have a reasonable belief that there's an impairment or disturbance, the functioning of the mind or brain. So, if someone's had a head injury and they're presenting as confused, that would be sufficient if it can be linked to the inability to do one or more of things in the functional test. If you've got a patient you don't know very well and they're presenting as confused, that confusion in of itself may well be sufficient. If you're caring for someone who there's a question mark about their cognition and they're waiting for assessment by the memory clinic, but you think that, for sake of example, they're having difficulty retaining information, and that's caused by potentially that cognitive impairment. You've got a reasonable belief that's caused by the cognitive impairment. Again, you can form that reasonable belief they lack capacity. So it doesn't need to be a formal diagnosis. It's a reasonable belief that there's an impairment or disturbance. And then our third part is what's sometimes referred to as the causative nexus. It probably sounds slightly more complicated than it needs to. And the way that I suggest you think about this is the inability to make the decision caused by the impairment or disturbance. So you want to be linking the two together, the inability to make the decision with that impairment or disturbance that you've got a reasonable belief the person has. And this is relevant, and you'll see why in a moment this is particularly relevant in terms of when you may then have situations where you might want to make an application or think about whether you need to look at the inherent jurisdiction. If you've got a case where someone's unable to make the decision, but either there's not an impairment or disturbance, you don't have a reasonable belief there's an impairment or disturbance, or there is an impairment or disturbance, but you can't link that to the inability to make the decision for whatever reason. So in terms of assessing capacity, in cases where there's concern about coercion or undue influence, as far as I'm aware, there's still nothing in our domestic case law that specifically relates to this. So as far as I'm aware, there's no case law that talks about how to go about assessing capacity in these circumstances. And there's a book called Overcoming Challenges in the Mental Capacity Act. So I don't think I've said yet, but all of these links, if you do get the slides shared with you at the end of this training, all these links are clickable. So anything that's hyperlinked, you can go and see what I'm referring to. And if you're feeling particularly enthusiastic, do some further reading about anything I talk about. And so what they do is they signpost this case from Singapore. So Singapore have got a Mental Capacity Act as well, which is practically identical for the purposes of assessing capacity to our Mental Capacity Act. And Kong and Keane and Rutkeen in this book say that the approach that the Singapore Court of Appeal took to conditions where dynamics in a relationship might be relevant to assessing capacity could be applied in the same way as it was in that case to our statutory framework for assessing capacity. So some things to think about where you've got concern about undue influence and you're doing an assessment of someone's capacity. It might be helpful for you to think about whether the person can retain, understand, or use the information relating to whether there might be undue influence being applied. So, for example, can the person grasp that someone else might have interests that are contrary to theirs? And then if not, so if they can't grasp that, the question is going to be, is that caused by a mental impairment? So all of this, you're still going to be linking it back to that functional test, that diagnostic test, that causative nexus. So if you've got someone who is having difficulty retaining that information, for the sake of example, impairment or disturbance, let's say for the sake of argument, they've got dementia, causative nexus, you're able to link the dementia to the inability to retain that information and therefore form that reasonable belief that the person lacks capacity. If you had someone with a learning disability, and let's say for the sake of argument, they're having difficulty understanding the information and applying it to their circumstances, again, you'd have to be linking that to the functional test, the test in the Mental Capacity Act. So functional test, they can't understand the information and apply it to their particular circumstances. Is there an impairment or disturbance? So the relevant learning disability. Causative nexus, you'd have to be then explaining why it is that their learning disability affects their ability to understand that information. The second question was whether the individual is vulnerable to undue influence due to their mental impairment, and whether their will is being overborne in such a way that they're unable to use and weigh that information. So they might be able to understand the information, they might be able to retain it, but in terms of using it and weighing it, is their level of vulnerability and their impairment or disturbance, the irrelevant impairment or disturbance, such that they're not able to use and weigh that information due to that coercion and undue influence. But again, you'd have to be linking it to that functional test. They can't use and weigh the information. They've got this impairment or disturbance, and therefore, and we can form a reasonable belief that they're unable to use use and weigh that information due to that impairment or disturbance. And then finally, and this is really being mindful of that second principle in terms of taking practicable steps to support the person, whether the person can't hope to get assistance in terms of making the decisions, where a finding of incapacity is because of the interplay between mental impairment and lack of support. So the question is going to be is, with the relevant support, could the person then be supported to make a decision for themselves, in which case we obviously need to make sure that we've done everything we can to get that support in place. Being mindful that the wording is in principle 2 is practicable steps. So you might be in a position where you've got someone who you assess to lack capacity in these circumstances. You then take steps to support them to make the decision, and that might be by taking steps to make arrangements for them to be for that undue influence to be taken away. But then if they then the question is going to be is how do they regain capacity, in which case they then obviously be able to go back to making decisions for themselves. And one of the cases that I'm going to talk about in a minute, that's what happened. So the person was initially found to lack capacity, deprived of their liberty in a care setting. They then regained capacity and went back into that position where they were being subject to coercive controlling behaviour. So, and as you'll see by that case study, that's then when you probably have to start looking at inherent jurisdiction if the person was exceptionally vulnerable and the risk was sufficiently high. Okay. So moving on to the inherent jurisdiction then. And just to be clear, I'm only talking about the inherent jurisdiction in the context of adults. So the inherent jurisdiction, you'll hear it referred to in the context of children as well. So we're not talking about that today. This is purely in the context of adults, so those aged 18 and over, and how the inherent jurisdiction applies to that cohort of patients. So just be mindful, a bit like when I was saying earlier about capacity referring to different things in different contexts. While the inherent jurisdiction will mean the same thing in broad terms, it does apply differently, arguably, to adults than it does to children. So we're looking at those aged 18 and over for today's training. So the inherent jurisdiction of the High Court, this is not necessarily a new concept. So before the Mental Capacity Act came into force in 2007, this was the source of declarations and orders relating to vulnerable people and in terms of care and treatment. So once the Mental Capacity Act came into force in 2007, the view was that it would provide a complete statutory framework for protecting people who lack capacity. But it wasn't necessarily envisaged that the inherent jurisdiction would continue to apply, but it does. There's been subsequent cases that obviously have found that the inherent jurisdiction can still apply to those that are exceptionally vulnerable. And the best definition for when the inherent jurisdiction might apply is provided in this case of SA that I referred to earlier. So while MUN-BJ in this case was reluctant to give a firm definition of who might fall under the auspices of the inherent jurisdiction of the High Court, what they did do is give some broad brush guidance, and it is very broad brush guidance, I think. So we can exercise, or the High Court can exercise its inherent jurisdiction in relation to a vulnerable adult who, even if not incapacitated by mental disorder or mental illness, is or is reasonably believed to be under constraint, subject to coercion or undue influence, or for some other reason deprived of the capacity to make the relevant decision, or disabled from making a free choice, or incapacitated or disabled from giving or expressing a real and genuine consent. So that is a very broad brush definition of who might fall under the auspices of the inherent jurisdiction of the High Court. And as is made clear in this judgment, it's not a exhaustive definition. If anyone is particularly interested in this topic, what I would say is there's a very interesting book that's been published last month by this gentleman, Rob George, and he's done a very comprehensive critique of the inherent jurisdiction in the context of children and adults, and it's actually freely available to download online. So if you follow this link, you can access that, and it doesn't cost you anything. And it's got various chapters on the inherent jurisdiction and how it applies to children and adults, and a very interesting analysis of whether or not it should be used in the context of adults. But I'm not going to dwell on that today because it's beyond the scope of of today's training, but it is an interesting read for anyone who is exceptionally interested in the topic. So when we're thinking about whether we can turn to use of the inherent jurisdiction, there's a few things we want to ask ourselves. First and foremost, we're likely to be asking ourselves whether the person has capacity within the meaning of the Mental Capacity Act to make the decision, because if they lack capacity, decisions are going to be made in their best interest, and any kind of judicial oversight, any court application is going to be via the Court of Protection. If the person has capacity, another question you might ask yourself is whether the Mental Health Act can be used to provide care and treatment. So Mental Health Act can be used to provide treatment to a person who has capacity where that treatment is for a symptom or manifestation of their mental disorder. And that can sometimes be interpreted fairly generously. So just being mindful of that, I suppose, in terms of any kind of medical treatment. Might it fall under the legal framework that is the Mental Health Act? If it's not a medical treatment decision, the next question is going to be, is there an alternative legal framework that might be used? So one example would be legislation for that's relevant to domestic abuse. So any other legal framework that might be used in terms of protecting this vulnerable person. If the person has capacity, Mental Health Act can't be used and there's no other legal frameworks available, you're then going to be asking yourself, what are we actually going to ask the court to authorise? And what you'll often be looking at, or what I think it's fair to say the court will often be expecting you to be asking them to do, is put in place something that's going to remove that coercion or undue influence to then allow that person to regain the autonomy to make their own decisions. So what we're going to ask the court to do to allow this person to regain the ability to make decisions. Again, this guidance note from 39 Essex Chambers is quite useful in terms of using the inherent jurisdiction. So I definitely signpost you to that as well. And that's where I've taken much of this slide from as well. Okay, so we're now going to have a little bit of a pause from talking about the inherent jurisdiction and briefly go back to assessing capacity. And apologies that this is a little bit, it does bounce around a little bit, the topics in this training, but I'm hoping at the end it will sort of all come together. And as we've mentioned, there'll be opportunity to ask questions as well. So hopefully that will be helpful as well if there's anything that does need to be cleared up. So this is an interesting case. This is, again, it's been the judgment was given this year in relation to the case of Sudishka, and this will be of interest generally as well as in the context of inherent jurisdiction. I'm going to be referring to it in. So this was a case Oh, and I haven't updated this slide. I've stolen this from another presentation, so I appreciate most, if not none of you on this call will have been to a training session I did in July. But anyway, this case looked at whether, if a person what do we do? Can we say someone lacks capacity if a person understands a diagnosis, prognosis, or treatment but doesn't believe it? So they understand that professionals have the view they've got this condition or prognosis or need this treatment, but they don't believe healthcare professionals that they need it. So a very high-level summary of this lady's case. She was a 19-year-old lady. She had a rare degenerative mitochondrial disorder, subject to mechanical ventilation, regular dialysis, and there was the view between both clinicians and an external expert that she was coming to the terminal stages of her illness. They wanted to give her treatment for palliative care for breathlessness and pain when it came to the end of her life, and she didn't want to have that treatment. She accepted the diagnosis, but didn't accept that there was a real prospect of her deteriorating anytime soon to the extent that she would need palliative care. So she accepted her diagnosis, she understood that, but she didn't believe that it was going to happen to her anytime soon. So, in fact, I'll just quickly go back a moment. So this case went to court of protection, and the judge in the first instance judge, so the judge that heard it in the court of protection, initially took the view that on the basis that she didn't believe she had the she was at risk of deterioration in the near future, that she lacked capacity. And there was two concerns arising from this case. The first was the reliance on a lack of belief to say that she wasn't able to make the decision, and she'd been assessed by two consultant psychiatrists, and both consultant psychiatrists were of the view that she had capacity. It was the treating team, so the physical health clinicians, that were of the view that she lacked capacity. So there's a disagreement between those two professional disciplines. So there was a concern about the reliance on lack of belief, and then there was also a concern about there was a very sort of I don't know if lenient's the right word, but approach to whether or not there was an impairment or disturbance. So the mental health professionals couldn't find any evidence of mental illness or any other impairment in her ability to make decisions for herself. So there was also a question around whether she had an impairment or disturbance in the functioning of the mind or brain. But the judge at first instance was satisfied that she was unable to make the decision, and took the view that there was an impairment or disturbance in the functioning of the mind or brain, albeit I think it was quite a generous one. So in the Court of Appeal, they took the view that her belief as to her prognosis and the likelihood of having effective treatment was relevant, but it wasn't determinative as to whether she was able to make the decision under Section 3. So that's where your functional test is: understand, retain, use, weigh, communicate. So it's relevant to that assessment of whether she can understand, retain, use, weigh the information, communicate a decision, but not determinative at all. And they were clear that there's no specific requirement for belief within that functional test. So what we're looking at is whether they can use and weigh the information. It doesn't say anything about whether they believe it. And they referred back to a pre-Mental Capacity Act case. So the case of MB, and in that case, the Judge Butler Sloss said an absence of a belief may, but not inevitably will, on the facts of a particular case, lead to a clinician or court to conclude that the functional test is not satisfied. and that the person in question does not have the ability to make the decision in question. So may, but not inevitably will. And then the judge went on to say, so this is Court of Appeal judgment. Once we displace an absolute requirement for belief, what we've got is a 19-year-old young lady who's fully conscious, suffering no identifiable mental illness or loss of brain function, and with the full support of a close-knit family, refusing to accept that her death is imminent, but says loud and clear to 2 psychiatrists that she wants to die trying to live. Take a great deal to displace the principle of autonomy and the presumption of capacity, no matter how unwise her decision to eschew palliative care may have been, seemed to a more mature mind. So following against that backdrop, the judge, in the judgment of the Court of Appeal judge, failed to give sufficient reasons for disagreeing with the unanimous view of the experts, so that's the 2 consultant psychiatrists, that Sadishka had capacity to make decisions as to her medical treatment. So no requirement for belief. It's relevant, but not an absolute requirement. And if you are going to form the view that someone lacks capacity because of a lack of belief, you've still got to link it back to that functional test. Why does the lack of belief mean that they're unable to understand, retain, use, weigh the information and communicate their decision? And it needs to be linked to an impairment or disturbance in the functioning of the mind or brain. I touched on this earlier, so I'm not going to dwell on this slide. This was the case that I mentioned before where the judge, the submissions were made on behalf of Mind about referring to the impairment test as opposed to diagnostic test. So I'm not going to dwell on that any more than that. Before the Court of Appeal published that judgment, Alex Ruck-Keene gave some commentary on the case. So this is this commentary was on the first instance judgment, and he observed that it might have been that this was a case that could have fallen within the inherent jurisdiction of the High Court. So even if the judge at first instance had reached the conclusion that Sadishka couldn't make the decision, so couldn't functionally make the decisions, that functional test. If there's then not an impairment or disturbance of the functioning of the mind or brain, we're going to be a bit stuck from the point of view of Mental Capacity Act, because we can only say someone lacks capacity within the meaning of Mental Capacity Act if they're unable to make the decisions, so they can't understand, retain, use, weigh, communicate. There's an impairment or disturbance to the function of the mind or brain, and the inability to make the decision is caused by that impairment or disturbance. So if the functional test, they can't do one or more of those things in the functional test, but there's no impairment or disturbance, this is where it's possible we might be turning to the inherent jurisdiction. However, this may be tricky, and that's where this training might start to raise more questions than it solves, because there's still no clarity in terms of case law on the extent to which the inherent jurisdiction can be used in the context of medical treatment and deprivation of liberty in adults. So we're getting into the realms of some uncertainty in the case law, and where we would very much want to be getting that legal advice as to whether or not it's something that we ought to explore in any particular case. So querying if it would actually have been legitimate to use the inherent jurisdiction in this case. And there was no evidence from the judgment that Sadishka was subject to undue influence or coercion. So the question would be, what basis would the inherent jurisdiction be used? Possibly exceptional vulnerability, maybe, I'm not sure. But also being mindful of the comments by the Court of Appeal in this case about the it would take a great deal to displace that principle of autonomy. And I think that would probably be fair to say in the context of use of the inherent jurisdiction as well. I think any judge would be extremely cautious around that, to be honest. But who am I to say that? So it'd be something to think about. So our first case that I'm going to touch on, and having said that I'm only going to talk about adults, so those aged 18 or over, this case does concern a 16-year-old, but I use it because it's a medical treatment case, and they are extremely few and far between in terms of use of inherent jurisdiction and adults. So this was a case concerning a 16-year-old who needed urgent treatment for leukemia. There was no identified impairment or disturbance. They looked to assess her capacity and no one could identify an impairment or disturbance. There's some parallels to that Sidishka case here. She didn't accept her diagnosis or the inevitability that she would become unwell without treatment. So the assessor took the view that she does not display sufficient capacity today to make decisions about her treatment safety. So this is where the word capacity is being used in a way that's not referring to Mental Capacity Act. It's capacity in the general sense. So if we go right back to the beginning of the training when I was talking about capacity being used in different ways in judgments, this is an example of that. It was likely there'd be a serious negative impact on her health if treatment wasn't started, and there'd be extreme consequences of that for her. She's expressed a wish for more time, but unfortunately, that would have probably caused serious harm. So the judge was satisfied that in terms of the balance between autonomy and preserving that right to life or protecting the life, balance fell in favour of intervention. Did go on to say that it's possible that this would end up being in court of protection. So it's possible that a more detailed assessment of her mental state, I suspect, would be undertaken, and it's possible that we might have ended up in a position where she was found to lack capacity and it ended up in court of protection. But the reason I include this case is I suppose it's not beyond the realms of possibility that a similar situation might arise in someone over the age of someone aged 18 or over, and there are some parallels to that Sidishka case. So maybe in such a situation where it's these circumstances arise, maybe this would be a situation that you might want to explore use of the inherent jurisdiction. I say that with all the caveats that I think the courts would be very reluctant to intervene in interfering with the autonomy of a capacitous adult. So, as I've alluded to just now, most of the case law has been in the context of welfare, not medical treatment decisions. For medical treatment, really important that if we are seeking declarations where someone might lose capacity in the future, that's one option that we might use it. So it's possible that we might make an application and ask for the inherent jurisdiction to be used where someone has capacity, but they might lose it in the future. So we want some anticipatory declarations almost. There's been recent case law that suggests that actually the Court of Protection might be able to do that as well, which is helpful. Or a declaration that doing something isn't someone's best interest, where we've got the power to do so under Section 63 of the Mental Health Act. So a declaration that the court is happy for us not to do something that we could do under Mental Health Act where the person's life is at risk. And being mindful where there's a risk to someone's life, public bodies need to be carefully considering whether they're actually required to bring an application. So thinking about that, moving on to our second case, this is about a lady called Mrs. Wolf or Ms. Wolf. This is a case that is due to go to inquest. The inquest is probably going to be listed in January, I believe, 2025. So the inquest hasn't been heard yet. But Miss Wolfe died in a house fire. So she lived in an element of self-neglect. She was a smoker, and she was known to public bodies. And as I say, she died in a house fire. And her son was very unhappy that the coroner hadn't said that this was an Article 2 inquest, so an inquest where the right to life had been engaged, and so he took this to the High Court for judicial review of the coroner's decision. And in this case, the court said that her capacity had been assessed, she was deemed to have capacity, and she was therefore entitled to exercise choice. She had the right to take unwise or inappropriate decisions, and there's no additional duties or responsibilities in these circumstances. That was the view expressed by the judge, the High Court judge. Again, there's been some commentary around this case that suggested that the inherent jurisdiction might have been something that could have been considered. So it will be interesting to see whether this is something that is explored as part of the inquest. But again, in the commentary where there's suggestion that the inherent jurisdiction might have been considered in this case, this difficulty has been identified around different approaches to the inherent jurisdiction by both professionals and the judiciary, so judges as well, about how it can be used and when it can be used. But the view in this particular piece of commentary was that some High Court judges might have taken the view that there might have been some intervention that might have been explored under the inherent jurisdiction. So I suppose the take-home message is to be getting advice in cases of this nature. I suspect in terms of frameworks and processes, this would be something where you probably have this these kind of cases under a MARM or a MARF, multi-agency risk management framework, and inherent jurisdiction might be something that's explored in that kind of forum for people who are exceptionally vulnerable, if there's concern about undue influence, and there is a serious risk of considered to be a serious risk of harm. One of the difficulties that arises in, well, not difficulty, one of the hot topics in discussion about use of the inherent jurisdiction is whether it can be used to deprive someone of their liberty. So taking a few steps back, I just want to quickly touch on what a deprivation, how we the circumstances that we can deprive people of their liberty, in what circumstances we can deprive people of their liberty. So what we want to turn to is Article 5 of the European Convention on Human Rights. So everyone has a right to liberty and security of the person. No one should be deprived of their liberty, save in the following cases, and then there's I think it's A through F, the sub sections, and in accordance with the procedure prescribed by law. So there's debate about whether the inherent jurisdiction can be considered to be a procedure prescribed by law, but let's say that it is for the purposes of today. The next question is going to be, is the person of unsound mind, and to what extent can the inherent jurisdiction be used where someone isn't of unsound mind? And there's an element of discussion that if they are of unsound mind, it's likely that then they will be found to lack capacity, although not always, I would suggest, but you know, it would add that that question would likely arise. So when we're talking about unsound mind, what do we mean? So in our domestic case law, we've got a definition within this case, but it refers to the Winterwerp, I think it is, case as a European piece of European case law that also defines unsoundness of mind. And so we're looking at someone to be reliably be shown to be suffering from a true mental disorder established on the basis of objective medical expertise. The disorder must be of a kind or degree warranting compulsory confinement, and the validity of continued confinement would depend on the persistence of that disorder or such a disorder. So this is why for anyone involved in the COP-DOL or community deprivation of liberty applications, this is why we need that medical evidence in terms of mental disorder, because it's a requirement of Article 5 of the European Convention on Human Rights. It's not sufficient that the person only lacks capacity. There needs to be mental disorder as well. So in terms of use of the inherent jurisdiction, in an emergency, it's likely, and this is probably actually not even just in the context of the inherent jurisdiction, but more broadly. So in an emergency, where there's reason, and this would include when we have reason to doubt capacity, but we haven't done an assessment or determination yet, it's likely to be lawful to detain someone, deprive them of liberty on an emergency basis for a short period of time to allow for these sort of medical assessments to be undertaken. And anything in terms of an authorization under the inherent jurisdiction would likely to be in this context. So it would be where there's no evidence of mental disorder, it's likely to be in an emergency for the purposes of assessment, and that would include getting a view on whether there is a mental disorder present. There's been a relatively recent case, so it's 2020, a case called Mazar, where the Court of Appeal, it was very much anticipated and hoped that the Court of Appeal might answer this question about whether it could deprive, the inherent jurisdiction could be used to deprive someone of their liberty under its inherent jurisdiction. Unfortunately, the Court of Appeal did not answer that question in that case, but we'll have a look at it anyway. Oh no, we won't. We're going to talk about Mr. Myers first. Okay, so this case of Mr. Myers was one where there's been some debate about whether or not the inherent jurisdiction was used to deprive someone of their liberty. So this was a welfare application. And this is the case I referred to earlier, where the person concerned was initially assessed to lack capacity. They then regained capacity. And the question was, they want to go back to the circumstances they were in before that were of concern. So Mr. Myers lived with his son in a bungalow. He was considered to be capable of and have capacity within the meaning of the Mental Capacity Act to decide where he lived and who he lived with. He was blind and diabetic, and he'd made a promise to his wife that he'd look after their son after she died. And the circumstances that Mr. Myers was subjected to in the house were pretty disturbing. His son did some extraordinary things, pouring this bucket of water over him, deliberately breaking his bed. I believe I'm right in saying that there was no heating, no hot water in the property. They were living in squalid conditions. Mr. Myers, and this is probably a contributing factor to him being found to have capacity, he articulated the relationship accosted him his home, relationship with his family, and the care that he needed to live comfortably and safely. His son was considered to be irrational, out of control, and manifestly emotionally dependent on his father. And there was a view that, if things continued as they were, there was a significant risk to Mr. Myers of further serious harm or death. So the local authority made an application to the High Court, to the inherent jurisdiction of the High Court, and they effectively sought an injunction, or I believe it was an injunction, that prevented Mr. Myers from living with his son. So the judge did that. He made an order. Mr. Myers was not allowed to live with his son. It didn't dictate where he was to live, but it did prevent him living with his son. And as I say, there's been some debate about whether or not this was a deprivation of liberty. The judge was of the view that it wasn't. I believe other academic commentators have suggested that it was. But this was a case where the inherent jurisdiction was exercised in this way. Now turning to Mr. Mazar. This person was removed from their home in the middle of the night without warning. And that was following an application to the High Court in an out of hours application. And in this case, I mean, there's an awful lot to this case. So if you want the full background and what happened, I would encourage you to read the judgment, the relevant parts of the judgment, because this is a very concise summary. But essentially, he'd had a period of illness, and as a consequence of that illness, he had a tracheostomy and was on a ventilator. He did live in the community. He had a peg feed. And he was considered to have capacity. He was provided with care and support, and for various reasons that had broken down, and it wasn't possible to find carers to support him on that day, as I recall. So professionals were very worried about him in terms of him being in the community without any care apart from his family. And they wanted to have an emergency admission to hospital. His relatives didn't agree to this emergency admission, and neither did he, and he had capacity, but he didn't agree to go into hospital either. Professionals were all concerned that he was under the influence of his mother and other family members, so they were concerned about that coercion or undue influence. Oh, that was their evidence in any event. So the outcome of this out of hours application, as I say, was that he was removed by police and paramedics in the middle of the night and taken to hospital. There was criticism of this case. So unfortunately, as I say, the Court of Appeal didn't comment on whether or not the inherent jurisdiction could be used to deprive someone of their liberty. He almost certainly was in this case. And it was done on an emergency basis. There was question about whether or not I believe that there was sufficient urgency or seriousness that he met the threshold for that kind of draconian intervention in terms of removing him from his home and taking him to a hospital. And there was also concerns about the absence of any kind of evidence around mental disorder. So, if he is being deprived of his liberty, where's the evidence for mental disorder? Is there an exceptional risk? And if there is, does the court have the jurisdiction in those circumstances to exercise its inherent jurisdiction? That's still a question that hasn't been answered. And also whether he was actually subject to coercion, controlling behaviour. I think there was debate about that as well. So the Court of Appeal gave some guidance for how professionals might go about, and solicitors and the courts might go about these kinds of cases. So the guidance was, unless it's an exceptional situation, you need to give notice to the person. So this was a without notice application. He didn't know that the application had been made to the court, and he didn't know they were going to turn up and remove him from his property. So unless it's exceptional, we do need to let them know this is what we're planning on doing. If we do make an application to exercise the inherent jurisdiction for a vulnerable adult, we need to give reasons for doing that. So tell them why, the court why we haven't informed them. and if we're making and if it's made without notice, that needs to be recorded in the order, and the reasons set out in the order. So that's something for the judge to worry about, and the lawyers involved. We need to be clear about the reasons for making such an application, and why we think the court needs to make the orders we're asking for, and also what we, and that's probably going to be your legal advisors, gives the court the power to make that order. And along similar lines, in terms of using the inherent jurisdiction for a vulnerable adult, we need to say the reasons for using the inherent jurisdiction. That's probably going to include why alternative legal frameworks aren't available, or that would certainly be something that I suspect any legal advisors would be asking you to explore and exclude, and they support you with that. And then again, the sixth one is something for the courts more so than us, but the court will then need to say in its judgment why they believe that they can make the orders they have. And if it's an out of hours application, it needs to come back to court as soon as possible, essentially, the earliest opportunity, because inevitably anything that's made out of hours has been done on an urgent or emergency basis, and it's likely that the evidence that is available will not be as comprehensive as it might be for a non-urgent application. Okay,